The rights of pregnant workers were debated in the U.S. Supreme Court today, and Jan Crawford was in the court.
Peggy Young was a driver for UPS, but in 2006, when she got pregnant, her doctor told her not to lift more than 20 pounds.
Once I got the note, I took it into the health nurse, and she basically said, we don't provide light duty for off-work incidents. Basically, you can't work while you're pregnant.
When UPS put her on unpaid leave, Young sued.
Everybody join the fight!
Arguing the federal Pregnancy Discrimination Act requires companies to do more to accommodate pregnant workers. Young lost in the lower courts, which said UPS did not discriminate when it equated pregnancy to an off-work injury. UPS recently voluntarily changed its policy, noting it now is actually ahead of many companies and government agencies, including the U.S. Postal Service, in accommodating pregnant workers with special work assignments. But Young continued with her appeal, and today the justices struggled over how far employers must go. Justices Ruth Bader Ginsburg and Elena Kagan were sympathetic to Young, arguing the intent of the Pregnancy Discrimination Act was obvious. Justice Kagan, it was supposed to be about removing stereotypes of pregnant women as marginal workers. But the other justices saw ambiguity in how the law requires employers to treat pregnant women. Justice Stephen Breyer, which distinctions are reasonable and which ones are not, and how do we tell?
Now, based on these arguments, it is impossible to predict how the justices will decide this case. If they rule against Young, though, Scott, women's rights groups say they will immediately look to Congress, urge it to change this law and make clear pregnant women are covered.
A decision in the spring or summer. Jan, thanks very much.